Take you to Chicago now, where Eugene Ornstead was convicted in 1994 for the grisly beating death of his second wife. But he's collecting some $55,000 a year. Why? Well, he was a firefighter and he had a pension. Despite being behind bars, he still gets the money. And he gets more benefits since he is a sole survivor. In effect, he increased his pension by beating his wife to death. The victim's outraged family might never see a penny of this money. Let's talk about it with our legal panel today. Dan Schorr is a former prosecutor. Rebecca Rose Woodland is an attorney. I guess, Dan, this kind of thing is actually, unfortunately, kind of common.
Yeah, we also have the same situation in New York where people who are felons, sometimes violent felons, are getting pensions. We have elected officials in New York who are in jail because of public corruption, still getting their pensions from being in elected office.
Why can't, being a convicted felon, why can't they write some side of the law that says you're a convicted felon, you lose your pension?
They can. They could amend the law and change it. In New York, it would require a constitutional amendment, and some people are proposing that. Here in Chicago, you have someone convicted of a violent murder, and he's still getting a pension. The public's paying for his incarceration and his pension. He
has collected, Rebecca, more than $800,000 while in prison?
John, I have to agree. The position is ridiculous. In Chicago and in Illinois, they should change the statute. But I also think that the victim's family should sue him in civil court for wrongful death. Remember with O.J. Simpson, Nicole Brown Simpson's family sued O.J. and there's an outstanding verdict? Then the victim's family can sue him for wrongful death. He's already been convicted, so that's a huge asset to the civil lawsuit. And then if they get a monetary amount, that gets removed. The pension gets removed from him to the victim's family. That's the way to do it.
He is 76 years old. He won't be eligible for parole till he turns 100, and he's not collecting that money in prison. Ironically, his daughter, he signed over power of attorney to his daughter, who is a Chicago police officer. She's a daughter by the first marriage, was not related to the woman who was killed. Here's an image of her. She already makes something like $78,000 a year as a cop, and apparently she gets to cash $55,000 a year in these pension checks.
Right, and the family of the deceased woman here, obviously they're outraged because they feel, why should someone who's related to this defendant, who's in jail for murder, why should they get money after he killed the wife?
Well, it's quite a story. We also want to touch on this because we talked about it earlier in the program. Charlotte Nash, the woman who was so horrifically maimed by that chimpanzee, she wanted to sue the state of Connecticut. The state just last week ruled, sorry, we cannot be sued in this case. She's going to appeal. Rebecca, what do you think her chances are?
You know, there is a possibility in this case that the state had evidence that this chimpanzee was very aggressive and violent. That's what her defense attorneys are saying. Her attorneys are saying there's evidence of violence in the chimp. The state knew. The state should have removed that chimp from any human interaction. If that's the case, then the appeal will stand, and then there will be a lawsuit proceeding. If that's not the case, the state says, hey, look, if we didn't know, it wasn't our responsibility. It was the responsibility of the woman who had the chimp.
That's essentially what the state is saying, right, Dan?
Yeah, it's a heartbreaking case. Here, the chimpanzee was legally owned by the person who had it at the time.
Who was a friend of hers,
right,
by the way.
It's since been made illegal, but at the time it was legal. The question is, was there a duty on the part of the government to intervene and take that chimp away? And that's going to be the issue here.
Well, the state is saying that it shouldn't be held liable because, at the time it was legal, and it was legal to have the chimp under state law.
That's what they're saying. Now, her attorney is saying, we have information that the state was put on notice that this chimp was aggressive and violent. If they do, they're going to have to prove it through evidence that's admissible in court. Any sort of records, notes, letters, or testimony on trial under oath that someone told the state.
Well, it's a $150 million lawsuit that she filed, and again, so far she has not been able to make it, take it to court against the state. She's living in a nursing home outside Boston, by the way, for now. We'll update our viewers on how that goes. Dan Schorr, Rebecca Rose Woodland, thank you both.
Thank you, John.
Thank you.